First of all, you have to start off with the proposition that municipal court motion practice is unique to municipal court. The normal motion rules in Part 1 of the court rules are specifically carve out municipal court practice as one of the areas. And you can see in Rule 1:6, it says that it applies to all the trial courts except municipal court. All right? So you really kind of look at municipal court as kind of sui generis in that regard. So in any event, we have to think about this in the context of strictly municipal court is municipal court and not related to anything that's in the Part 1 rules, all right? So here's the main rule about making motions in municipal court. I think I skipped something here. Oh, 1 second. No, here we go. So it's 7:7-2. Except as otherwise provided. And there's a little bit of a mistake in the rules, which I'll show you about in a second. 7.52 is the motion to suppress rule. Motions in municipal court and answers to motions, if any, shall be made orally, unless the court directs that the motion and answer be in writing. So right off the bat, you see that the rules of court, the preference here, in fact, is mandatory that motions be made orally. And this is done really as a result of two things. It's a tradition that the rule embodies that most of the things that you're dealing in municipal court are kind of simple. That's number one. And number two, many times you're dealing with lay people who are going in before the court, and presumably they're representing themselves and they can make their own motions. So in order to maintain a kind of a simplicity of procedure, technically all the motions should be made orally. The little mistake in the rules here is that the post-conviction relief applications also by its own rule, which is 7:10-2, also have to be made in writing. That's another rule that cannot, another motion that cannot be done orally, okay? Now, notwithstanding all this, I want you to think about the kind of the complexity of municipal court. I mean, this rule might have outlived its usefulness in some respects because many things that we do in municipal court these days are enormously complex. And notwithstanding the fact that the rule says you should make the motions orally, oral motions in some of these complex matters is just completely inappropriate. And there's a recognition of this in the case law. I just want to point it out to you, and we'll come back to that. 772 has essentially been modified through this case law in State versus Hollop. This is a 1992 decision written by Judge Gruccio, and in the pantheon of municipal court published decisions, this has got to be up there in the top 10, at least, if not the top 5. Take a look at this language from the Appellate Division. Lastly, we are constrained to comment the effect of 772, which permits motions in municipal court to be made orally and informally. As our municipal courts mature and become responsible for disposition of more complex, more serious in terms of penal consequences, and more communally important cases, more formal practices become essential. We understand that much of the subject matter in controversy in municipal court is minor, and in such cases, informal practices should continue. But in the more significant cases, a more careful, thorough procedure is warranted. There's a recognizable difference in the analysis of discovery in a drunk driving case as compared to one involving a stoplight violation. The mere fact that the court rules allows informality does not give broad license to counsel. So I want you to kind of keep this in the back of your mind, and when you're approaching a motion that is other than something that's very, very simple, you really ought to be doing it in a professional manner, meaning filing a formal motion with a brief, with certification of counsel or whatever is necessary, with whatever exhibits you need. Not only in terms of professionalism, but also in terms of the persuasiveness if you want to win the point you're trying to make. My own feeling as a practitioner was that any time I would file a motion orally, not orally, but with all the backup paperwork, it would at least alert the prosecutor and the judge that I'm serious about this. This is not some, trifle that we're talking about. Judge, I wanted to ask your impression about this in terms of oral motions versus, like you've just got unsolicited a motion that had a brief and exhibits a certification, how you would treat them. Pretty much we want to see written motions, and the reason is that gives us an opportunity as judges to prepare, at least look ahead of time and see what you've submitted, maybe not spend a lot of time on it, but be aware of what's coming before us. It's really, really important for us to know that. As you all know, the court is very, very busy, a lot of things happening, and if the judge has a heads up on it, he or she's going to be in a position to be prepared to address it and not have to fumble around with it and try to figure out, okay, what am I supposed to do with this? So practically speaking, the judge is going to appreciate that, gives them an opportunity.
him or her an opportunity to get ready for that particular motion, and also not be surprised by what you may be asking. As an example, if you're going to make a motion for a judge to recuse himself or herself on a case, you know, the first time the judge shouldn't hear that is when you appear in court and say, Judge, I'm making a motion for you to recuse yourself. If you give the judge a heads up, he or she can sort of evaluate that and see whether, in fact, there's something to your motion. So I think that, as Bob indicated, that this rule has been modified by Hollop, as he indicated, but really you should, except in extraordinary circumstances, make those motions in writing so that the judge has the opportunity. They don't have to be detailed. You don't have to have a brief in support of it. Make a motion, and if the judge wants something, he or she will ask you for it in addition to that. But once you make the motion, you've now put the judge on notice, hey, here's an issue you're going to have to deal with, Your Honor, and that way there's not going to be any surprises. Judges appreciate that, gives them a heads up, and you're probably going to get a better decision that way as well.
Did you find that that it was more powerful to have something in writing in front of you, citing case law and things like that, as opposed to somebody just standing up and kind of winging it with an oral application?
No doubt about it. I mean, that's the key is that judges always say that, you know, if the attorney loses, it's not because the judge did something wrong, because, as you know, the judges never think they do anything wrong. But the problem they always say is it's one of the attorneys didn't do his or her job. If you give me the information as a judge, then I can evaluate it. You give me the cases and I can look at them. I won't agree with you, but if I get that information, I can make an informed decision. Otherwise, you're shooting from the hip and I'm shooting from the hip, and it's more difficult for you to get a good decision that way. So the more information we have, the better off it is.
Your Honor, I object!
And why is that, Mr. Reed?
Because it's devastating to my case!
Overruled.
Good call!
It'd probably be time for me to recommend to the community municipal courts that they make this discretionary as opposed to making it mandatory, you know, because really the days of simple practice in municipal court are long gone. You know, just think back to 1992. I don't think the courts were hearing the same types of cases that they are now, with motions to suppress and domestic violence issues and bail issues and all the other stuff we're going to be talking about tonight. So it's very complicated.
I've never heard a judge complain that this person didn't follow the rule because they should have got permission before they filed that motion. Yeah. Never has that happened.
You ever kick anybody out of court because of that?
Never done that.
Can I ask you, just based on your 5,000 years of experience doing this stuff, I know you've had situations where defense counsel would file a brief in motion and do a professional job. Prosecutor would not respond and just attempt to get up on his feet and wing it, you know. I mean, from your perspective, didn't that usually put the prosecutor at a big disadvantage?
Absolutely. And I would, you know, they'd be getting a look from me, too, as to, come on, you have an obligation here to do something. Even under the rules you don't. If the attorney files a motion, come on, you got to respond. And quite honestly, I think we've all experienced where the judge will say, okay, file a brief, and you'll get a brief from defense counsel, and the prosecutor won't even file a response, even when the judge orders it. It doesn't happen. Okay.
Judge Gruccio in Hollop went on to say the following motions and supporting documents assist the municipal court judge in making a fair and considered decision. A motion limiting the time for completion of discovery in this case would have ensured notice to the prosecutor and avoided the waste of time by defendant, the expert witness, and defense counsel.